Welcome to GoToWebinar, Web Events Made Easy.
People can hear you. Hi everyone. Please someone give us a heads up if you can hear us. Type in and let us know that you can hear the sound. We may have had an issue with the microphone when we got started. We're getting a lot of notes. Okay. Thank you everybody for your feedback. Apologize for that little false start penalty there on the offense. It's preseason, so we're getting rolling now. Thanks everybody for joining us, and good afternoon. We're getting started with the webinar, Look Before You Leap, preparing for SBA's new rule on size and status representations. My name is John Williams. I'm a partner with the Government Contracts Group at PilieroMazza, and I'm joined today by my colleague Peter Ford, who's an associate with the Government Contracts Group. Peter and I are very glad that everybody could join us today. We're excited to talk with you about the new rule on size and status representations, the so-called presumed loss rule. Over the next hour, Peter and I are going to talk to you about the presumed loss rule. The first half of the webinar is geared toward helping you to understand the elements of the new rule. And during the second half of the webinar, we're going to give you several suggestions about what you should be doing to prepare for the new rule and to ensure that you don't face liability. Because we anticipate a lot of questions, our plan is to save the last 15 to 20 minutes to answer your questions. You can submit questions throughout the webinar using the question box in the webinar dashboard on your screen. Just type in your questions as we move through the material, and we will answer as many as we can at the end of the webinar. If we don't get to your question during the webinar, we will follow up with you afterward to make sure we answer everyone's questions. So don't hold back. Please fire away as we're moving through. Also, just so everybody knows, you will be getting an email either later today or tomorrow with a link to the slides and the audio. So if you missed anything or you want to share this with other folks in your organization, you will get, as an attendee, you will get an email with a copy of the slides and the audio. We're also going to post it to our website. And if for some reason either of those don't work out, just feel free to contact Peter or me directly, and we'll be happy to get the material to you. So with that introduction, let's dive in and start with understanding the rule. Mark your calendars because the rule goes into effect 2 weeks from today on August 27th. So that's hence the timing for this webinar. We want to get this information out to everybody right before the rule goes into effect. The rule, it goes into effect in 2 weeks, but it's been a long time coming. The origination of this rule is the Small Business Jobs Act of 2010, which had the presumption of loss provision. And the Jobs Act established a presumption of loss to the government from a size or status misrepresentation that's equal to the total amount expended on a contract obtained by misrepresentation. The purpose of the presumption of loss provision in the Jobs Act was to prevent and deter fraud and misrepresentation in small business procurements. The idea was to create a significant amount of potential damages to the government that would make these cases more readily prosecuted. And essentially make them sexier cases, bigger dollar cases, so you get prosecutors more interested in going after firms that misrepresent size and status. So this law, the Jobs Act in 2010, says that the presumption of loss, in other words, the damages to the government for a misrepresentation, can be up to the entire value of the contract that was won by misrepresentation. So obviously that can be a very significant penalty. The SBA, under the law, the SBA was directed to implement rules, in particular rules to provide protections for companies that make unintentional errors. And the SBA proposed those rules in October 2011, and now we're just getting to the final rules roughly 2 years later. In addition to the presumption of loss provision, which is where this rule gets its name. There are several other key aspects of the rule. We're going to run through each of them with you during this first half of the presentation. There are provisions regarding deems certifications, signature requirement, that's new, limitation of liability provisions, annual recertification requirement. There are aspects of the rule that address applicability to subcontractors, and then there are also the penalties. So I'm going to start by talking about the presumption of loss provision. And this is not a verbatim quote, but this is essentially what how the rule reads regarding the presumption of loss. It says that in every contract, subcontract, cooperative agreement, cooperative research and development agreement, or grant that is set aside, reserved, or otherwise classified as intended for award to small or 8A or SDB or SDVOSB, hub zone, woman-owned or economically disadvantaged woman-owned small firms, there's a presumption of loss to the government based on the total amount expended on the contract, subcontract, cooperative agreement, etc., whenever it is established that a firm willfully sought and received the award by misrepresentation. So as I mentioned before, the idea here is to create the significant amount of damages that the government could go after, setting that at the total amount expended on the contract, which raises a question: if there's no money expended or little money expended on the contract, then that would limit the damages. But in theory, it could be the entire amount of the contract, which could be a significant amount of damages for the government to go after. We've underlined here the willfully sought and received language, so that we're going to get into that in more detail later, but the sought and received is important. It indicates that the presumption of loss provision applies only when you've actually received the contract. There are some other penalties under the new rule that apply regardless of whether you receive the contract, but for the presumption of loss, it's willfully sought and received the contract by misrepresentation. When the SBA explained the presumption of loss provision in the new rule, they indicated that it was intended to be broadly inclusive, to cover set-asides, reserves, partial set-asides, even price evaluation preferences and source selection factors for small businesses, and basically anything else under the sun. So the applicability of the rule is broad. It casts a wide net. However, it is interesting to note that the final rule does not establish an irrefutable presumption of loss, and that is a positive for contractors. The proposed rule that came out in October 2011 established an irrefutable presumption of loss when there was willful misrepresentation. But the new rule that goes into effect in a couple weeks dropped the word irrefutable, and so there's going to be a rebuttable presumption in the new rule, which means that if you are subject to enforcement under this rule, your prosecution or alleged liability, you have the opportunity to present mitigating circumstances to demonstrate why your liability either should be avoided or limited. And that's critical. We're going to spend a good deal of this presentation as we go along talking about the things that you can do and the things that you should do to mitigate your liability. So the rebuttable presumption as opposed to irrefutable presumption is a key aspect of the final rule. The SBA also noted, and we're going to come back to this point several times, that it's the trier of fact, in other words, the judge or the jury, not the SBA, that's going to decide whether a presumption is rebutted. And that's going to be done on a case-by-case basis in civil and criminal proceedings. So, the discretion that the new rule provides in terms of being a rebuttable presumption is very favorable. But and the case-by-case inquiry gives you the opportunity to provide circumstances to show that you should not be found liable. But there are some instances in the new rule where this discretion could cut against contractors. So the final rule in several places, and this is one of them, went away from certainty in favor of providing discretion to the trier of fact, and that's helpful in some respects and not as helpful in some respects for contractors, and we're going to talk about both. But for now, I'm going to turn it over to Peter to talk about deemed certifications.
Deemed certifications. So under the new rule, actions that are deemed affirmative, willful, and intentional certifications of size or status include submission of a bid, proposal, application, or offer for a federal grant, contract, or subcontract that is reserved for award based on size or status, or that in any way encourages an agency to classify the bid or proposal based on size or status. A deemed certification also includes registration in any federal electronic database. So we're talking about SAM, ORCA, etc., for the purpose of being considered for award of an opportunity based on size or status. With regard to the registration in any federal database, this slide just gives you a little background as to why it's actually in the final rule and why it is so broad. With regard to why this requirement is in the new rule, it's in there because it was in the Jobs Act. And because it was in the Jobs Act, the SBA could not eliminate it and was in fact required to put it in. As to why it's so broad, meaning why it covers any federal electronic database, well, that's because agencies rely on registrations in these types of electronic databases for purposes of meeting their goals. The third bullet point on this slide raises an interesting practical question. If you read the preamble to the new rule, it states that a firm is expected to verify its representation in SAM every time it submits an offer on a government contract. Okay, so what is the impact then on task orders under set-aside contracts when recertification is not explicitly required? Well, we think there will be no impact, and that's because a task order is not a contract reserved based on size or status. And you know, we have had some informal discussions with the SBA on this topic in particular, and the SBA believes that the certification, the deemed certification requirement, does not apply to task orders. With that said, in at least one case before the SBA's Office of Hearings and Appeals, the judge indicated that this type of contract language did apply to representations made in a proposal under a task order contract set aside for small businesses. However, that statement made by the judge was only dicta, and of course that means it's not binding. But
yeah, so, and this is John, I'll just jump in on that point. You know, as a lot of you may be aware, on a task order basis, an agency has discretion to require size recertification. They don't necessarily have to. If they don't explicitly request recertification at the task order level, then it looks like the new deemed certification provision will not apply, because without that recertification requirement at the task order level, it's that particular task order doesn't fall under the ambit of the new rule. At least that's how we're reading it, and that's how SBA seems to be interpreting it. But if you do have a task order that explicitly requires recertification, I think you got a different ball game at that point, and you're probably within the realm of the deemed certifications at that point.
okay, so the new signature requirement: every proposal, bid, application, or offer must contain a certification concerning the firm's size or status, and that certification must be signed by an authorized official. and it's wet signatures only, meaning electronic signatures simply will not suffice. Notably, SBA acknowledges in the new rule that the new signature requirement will necessitate changes to the FAR clauses concerning representations and certifications. So this, of course, begs the question, until those changes are adopted by the FAR Council, what should contractors like yourselves do in the meantime? We will get into this in more detail later, but in a nutshell, the SBA seems to think nothing at this point. However, the law is on the books and effective as of August 27th, so there are things that you might want to start doing differently.
Thanks, Peter. So the next element of the rule that I'm going to talk about are the limitation of liability provisions. Perhaps the most important aspect of the rule from everybody's standpoint in terms of defending against or planning to avoid the potential of liability under this scary new presumed loss world that we're now shortly going to be living in. The rule provides that the various penalties, the presumption of loss, even the deemed certification and signature requirement provisions may be determined not to apply in the case of unintentional errors, technical malfunctions, and other similar situations that demonstrate that a misrepresentation of size was not affirmative, intentional, willful, or actionable under the False Claims Act. The rule goes on to indicate that a prime contractor acting in good faith should not be held liable for misrepresentations by its subcontractor. And the rule provides that there won't be any liability when government personnel erroneously identify the firm as small without any representation or certification by the firm or the firm's knowledge. I think that'll end up being a fairly narrow circumstance, but in any event, that is one case where there clearly won't be any liability. The rule also provides some factors that may be considered when determining whether liability should be limited. And the factors specifically mentioned in the rule are listed here on this slide. The firm's internal management procedures governing size and status representations, the clarity or ambiguity of the representation or certification requirement, and the efforts made to correct an incorrect or invalid representation in a timely manner. And on that last one, one of the comments to the proposed rule asked the SBA to specify that 30 days, a correction within 30 days would be considered timely. And the SBA declined to put that into the final rule because they said that, again, this is a case-by-case determination that's going to be left to the trier of fact. So in theory, a correction that's done in less than 30 days might not limit liability, and at the same time, a correction made in longer than 30 days could limit liability. It'll just depend on the circumstances. So we don't have any bright line rule. We're not going to be able to tell you if you catch it and fix it within X amount of days, you're going to be okay. It's going to be decided on a case-by-case basis and under a reasonableness test based on the circumstances. It's important to point out that this list of items from the rule, that relevant factors that may be considered, is not exhaustive. So if there are other things that apply in your situation that go to showing you acted in good faith or that it was an unintentional error, etc., they should be considered. This next slide is I think this is the most important slide with respect to limitation of liability. And I didn't mention it on the last two slides, but you probably noticed that we had underlined a few of the words, may and should. And when I talked about the rule at the outset, I said that the SBA went away from very definitive statements in the proposed rule in favor of more discretionary language in the final rule. And this is an example of how the change to more discretionary language arguably is to the detriment of contractors, because the proposed rule said that there shall not be liability in the case of unintentional errors, etc. Whereas now it says there may not be liability in those circumstances. Similarly, with respect to those relevant factors that should be considered, the proposed rule said that they shall be considered in determining whether there's liability, whereas now the final rule says you may consider those factors. And the Jobs Act required the SBA to put out rules to help protect firms against unintentional mistakes. And the proof will be in the pudding as these rules are applied going forward, but the change from shall to may, making this discretionary, to us limits the effectiveness of this protection, because even in a case of an unintentional mistake, theoretically a contractor could still face liability. And the SBA, in their explanation of the rule, said that they believe that a good faith misinterpretation of their rules should not be considered a willful misrepresentation. And in another spot, they also said that, or they suggested that new or unsophisticated firms or firms that make unintentional mistakes should be given leniency or shouldn't be prosecuted under the rule. And that's great for them to provide that explanation, but the SBA is not going to make that determination ultimately. Whether an SBA regulation is ambiguous or whether a firm's misinterpretation was made in good faith, those types of determinations, that case-by-case inquiry is going to be made by the trier of fact, by a judge or a jury, and at an earlier stage by a prosecutor, not the SBA. So the SBA's beliefs, as explained in this final rule, should be helpful in those types of actions and in understanding what was intended by these rules, but they're not an ironclad requirement for how the trier of fact has to act. So it's going to be a case-by-case basis, and that discretion, I think, really drives home the importance of doing as much as you can to mitigate and eliminate misrepresentations, to do be as prepared as you can, because there is no circumstance where we can definitively tell you will have no liability, except for that fairly narrow circumstance I mentioned where the fault is solely on the government.
So under the new rule, firms must certify as to their size and status in SAM at least annually. And if you don't, your failure to do so will result in the firm not being listed in SAM as small or with the relevant status until that firm recertifies. Notably, contract length is irrelevant to this requirement for annual recertification. And this requirement is separate and distinct, for example, from the requirement that COs must request a firm to recertify as to size or status, at the end of the 5th year on long-term contracts. The annual recertification requirement does not apply to 8A or hub zone firms, and that's because the SBA provides these designations. It does, however, apply to SDBs, SDVOSBs, WSOBs, and EDWSOB firms. The key takeaway here, however, is that the onus is on you to recertify. The SBA is not going to send you a friendly reminder to get this taken care of. Subcontractors, and I saw we already had a question about this, but the presumed loss rule also applies to subcontractors who willfully misrepresent their size or status to receive a subcontract. The final rule, or the new rule, does not discuss or limit instances where this would come into play, but one situation that does come to mind is where a subcontractor is certifying in connection with an award made pursuant to a large business's subcontracting plan. The SBA believes that prime contractors that rely in good faith on the written representations of their subcontractors should be insulated, protected from liability. However, will the trier of fact agree? And again, as John pointed out, at this point we don't know. And that is because, the SBA isn't going to be deciding these cases. So what constitutes good faith reliance on a subcontractor's representation? Again, we don't know. You clearly need to do some due diligence, and later on we will give you some suggestions as to what this due diligence might actually entail. So penalties. 3 types of penalties under the Act: suspension and debarment, civil penalties under the False Claims Act and other laws, and criminal penalties. And the dollar amounts and the years of imprisonment that we listed under the criminal penalties are the max, so it's not necessarily meant to scare you. It is important to note that the presumption of loss penalty depends on receipt of a contract. But those other penalties, including suspension and debarment, do not. And if you're wondering where this presumption of loss liability falls under, that would be included under the civil penalties and other laws category.
Okay, so we've got a nice foundation now in what this new rule is and what it requires and some of the scary aspects of it and some of the potentially helpful aspects of it. So what should you do? We've got several suggestions, and we've grouped them under these categories. Internal review, develop and implement corporate policy and procedures for size and status representations. Those 2 items are really things that you ought to be doing right off the bat. The next 2, perform risk analysis for your projects and partners and modify your teaming agreements and subcontracts. Those you could roll out on a going forward basis as opportunities come about that warrant it. And then we're going to wrap up with a few additional suggestions, and I'm going to let Peter get started with the internal review.
Okay, the internal review, and as John mentioned, this is something that contractors should and can be doing right away. And what we mean by an internal review is essentially you need to thoroughly assess your size and status representations in SAM to either, 1, get a clean bill of health, or identify potential issues and go ahead and address them. The goals of the internal review in a nutshell are to catch past misrepresentations, ensure that your future representations are accurate, and demonstrate good faith. It's critical that you document the internal review. And what we mean by that is you need to start building what we would call a compliance file. It's not required by the new rule, but it just makes sense. And the point here is that you're doing this, meaning that you're documenting this internal review with an eye towards someone else having to defend a future claim of misrepresentation down the road. So with that said, what should this documentation include? Well, at a minimum, it should detail what the scope of the review was, when the review was conducted and by whom, what conclusions came about, and what corrective measures were taken, if any. Again, while not required, a compliance file supporting your reps and certifications might at some point down the road help you rebut presumption of loss liability. So more on the internal review. Seek counsel and don't go it alone. And this is by no means supposed to come across as a shameless plug, but your attorney is more familiar with the affiliation and the small business rules and regulations, and you can get a letter from your attorney essentially signing off on your status. And what that does, it goes to good faith efforts, and it also goes to your peace of mind. So the scope of the internal review. Here, you must look beyond tax returns and employee headcount. What you really want to do is put yourself or your attorney in the SBA shoes and treat the internal review like a mock size determination. So one of the things you might want to do, as painful as it may sound, is complete an SBA Form 355 application for a small business size determination. A good internal review requires a thorough affiliation analysis. Again, you got to look beyond just your tax returns and the employee headcount. You need to examine financial statements, corporate documents, the contract backlog, your revenue breakdown by customer, outside interests of owners and officers, and recent M&A activity.
Okay, so you've done your internal review. You got your clean bill of health, or you found out you had some weak spots and you're working to address them. What's the next thing you should do? The next thing, or really something you should do concurrently with this internal review, is implement policy and procedures related to size and status representations. This is something that's mentioned specifically in the rule. It's the first relevant factor in the limitation of liability provision. The first thing they say that they may consider is your internal management procedures for size and status representation. So it's really a no-brainer that you go ahead and develop, if you don't have them already, develop and implement procedures related to size and status representations. It's going to help you to continue to build your compliance file, like Peter mentioned, something that we could use potentially several years from now if an issue is ever raised about one of your representations. It's also one of your best tools for ensuring that the representations you're making right now are accurate. And with the new rule and the new penalties and the presumption of loss, we think that contractors would be taking a big risk to go forward making size and status representations without some form of internal policy and procedures. So with respect to the policy, what you want to have here is a basic statement of your company's adherence to the laws and regulations for the small business programs, that you're going to take all steps necessary to ensure that your representations are 100% accurate 100% of the time, and that you're going to quickly take action to identify and correct mistakes. I think the key for the policy is that this is part of your company's mission statement. You drill it into your employees. It's very clearly understood to be a key aspect of your corporate philosophy, just how you do business. As a small business, your size or your status are one of your key assets, and this is something that you want to make sure all your people understand will be vigorously protected. And in terms of procedures, this is where you're going to lay out exactly what you're going to do to ensure that your size and status representations are accurate. And what we've done on this slide is just list some examples of possible procedures that you could implement for your size and status representations. There are many, most contractors are going to have some form of policies or procedures in place that are mandated or recommended by the FAR, whether it's an organizational conflict of interest mitigation plan or a code of ethics. You probably already have a portfolio of documents like that, and our strong recommendation based on these new rules is that you add to this portfolio procedures related to how you make size and status representations. So if we just tick down the list here, you pick a date for annual updates of SAM and other online databases. Since you now are required to do this once a year, your procedure should specify a date when you're going to make that annual update. And maybe you want to set that date to be the same day as your annual board meeting or something like that so that you don't forget and it's clearly on your radar every year. You want to have procedures spelled out for it. Every time you have to make a representation, what are the steps that you have to go through to do it, and who's going to be responsible for that? You want a clear line of authority. Designate somebody as the person in charge of that. And what is that person supposed to do as an initial line of defense in making the representation? Check SAM, confirm revenue or your employee headcount, determine if there's been any triggering events, and I'll mention triggering events in more detail in the next slide. And then document the review. We would recommend that you come up with a checklist that this person can tick down the list. Okay, I checked with so-and-so regarding our revenues, and we're fine. I went to HR and got the head count. We're good there. There's been no triggering event. Sign off and put it in the file. And then for circumstances where maybe there is a triggering event or something else about the certification or representation is unclear, the procedure should specify how the matter gets escalated, both internally and externally, so that a more complicated situation can get vetted. And this goes back to Peter's point, don't go it alone. There will be circumstances where it would be prudent to get an outside advisor's input on whether or not certain circumstances impact your ability to represent size or status. And having gone through that hoop and checked the box and gotten a letter or whatever it ends up being, will go a long way both towards ensuring that you make an accurate representation and that you have enough of a file built up to be able to say that even if somebody else disagrees and thinks that you made a mistake, that you can show them you had a good faith basis to make the representation that you did. We've got some other items on here. I mean, a lot of this is fairly self-explanatory or common sense. Make sure your people are trained on these procedures. And Peter will talk a little bit later about the risk analysis component here. But I mentioned triggering events. There are some cases where your size or status won't be up for much debate. It'll be fairly clear. It's just a matter of your own revenue or your head count, maybe even certain forms of affiliation like common ownership are pretty easy to step through, and you're not going to have to ring up your attorney or your accountant for those types of situations. But there are a lot of cases where there is at least some gray area in terms of the impact that circumstances or events can have on your size or status. And these things all come from the SBA's affiliation rules. We think that the new presumed loss rule just underscores the importance of understanding SBA's affiliation rules and how affiliation can adversely impact your size or status. And we've listed a few types of affiliation on here that can tend to be a little grayer in terms of how easily you can tell when they've occurred and what impact they have. So these would be potential triggering events, which we've now listed on the next slide. Emanating from those affiliation rules on the prior slide, you have certain events like changes in ownership or management, mergers, acquisitions, and spin-offs, teaming arrangements with large businesses. That teaming arrangement bullet gets to the ostensible subcontractor rule, which I know is everybody's favorite, and Peter's going to talk a little bit about that in the risk analysis. Joint ventures. Every joint venture is affiliated. There's automatic affiliation based on joint ventures. That doesn't mean you can't go forward with it. The rules specify how you determine size or status for joint ventures, but you need to make sure you step through it. It's a triggering event that would impact your size or status representation. Performance of significant number of contracts over time with one firm that account for a high percentage of your revenue. This goes to the economic dependence affiliation. And it's something that isn't probably going to arise overnight. It's going to develop over time as you might continue to do a lot of your business with one firm. And if you see that happening and you're assessing that over time, you'll be in a better shape to take steps to mitigate that before it gets to the point of adversely impacting your size or status. But it's something that should be looked at as part of the annual reviews and the internal review and sticking to your policies and procedures. So when you have a triggering event, you want to follow those procedures, seek external review when you need it, and document the file.
So performing a risk analysis, as John mentioned previously, when and how a risk analysis is going to be conducted is something that you're going to want to include in your policies and procedures. So with that said, I mean, what does this mean exactly? Well, for new business opportunities, anytime that you're proposing a large business subcontractor or even a small business subcontractor, you need to be aware of ostensible subcontractor affiliation. And in this regard, you need to make sure that you as the prime contractor can perform the primary and vital requirements of the contract and that you're going to be controlling the project. Just in general, you need to be asking yourself, do you have a good faith basis to pursue with the required size or status? And if the answer is no, then get out while you still can and just, avoid the opportunity altogether. A lot of this is stuff that most small businesses are already doing. However, the new rule emphasizes the importance of doing so. So with respect to new business partners, you need to assess the risk at the teaming agreement stage. And why is that? Well, that's because subcontracts are often entered into only after the contract has been awarded, which for purposes of the new rule is too late. The damage, if any, has been done, so to speak. So again, I mean, there are questions that you should be asking yourself. As a small business, can you perform enough of the work in the key areas? Are you comfortable with the indemnification your partner is likely to require? What have you done to verify your partner's size and status? And I guess this is more of a practical point. You should expect that companies and people are going to be coming to you asking for protections. And in a similar vein, you need to start requiring protections from other people. So teaming agreements and subcontracts, and we touched on this, at least some of this already. Both prime contractors and subcontractors need to take precautions when they're depending on the size or size representation of another firm. So for prime contractors, getting a written size and status representation from your subcontractor and putting that representation in the teaming agreement and the actual subcontract is important. And it's important that that written representation is based on current financial and employee data. In addition to getting a written representation, go ahead and pull up your subcontractor SAM profile and look to see if it contains the appropriate size or status representation. And then, of course, print a copy, and this is just another thing that you should be adding to your compliance file. And then for subcontractors, protect yourself from liability and recoup proposal costs in the event of a misrepresentation by the prime by inserting indemnification clauses in teaming agreements and subcontracts.
Thanks, Peter. So I'll wrap up with just a few additional tips, and then we'll turn to as many questions as we can get to in the roughly 15 minutes we have left. Based on the wet signature requirement, it's our recommendation that you look at ways that you can incorporate this into your proposals now, as opposed to waiting for the FAR to be modified. The SBA, when they explained these new rules, they specifically declined to permit electronic signatures. As Peter mentioned, they said that they can't allow electronic signatures under the law. They have to require the so-called wet signature. But they acknowledged that the FAR would need to be changed because right now the certification clauses don't allow for a signature on the same page, a wet signature on the same page as when you're making your representations. So arguably, you shouldn't face any liability for not complying with this until the FAR's been changed. But this law has been on the books, and the rules are now about to go into effect, and the SBA is not the one that's going to do the enforcement ultimately. So for those reasons, the best practices would be if there's a way you could incorporate onto the cover page of your proposal or a cover letter, something within how you're currently doing your proposals that you're signing on the page, then and on that same page stating what size or status you're claiming for the procurement, that should help you to be able to say you're in compliance even before they change the FAR. And the last point we want to make is with respect to mergers and acquisitions. This particularly for firms that are looking to acquire a small business, but it can cut both ways. You need to take into account at the due diligence stage and also when you're putting the M&A documents together that there's a potential now for additional exposure. There's other areas that need to be reviewed, maybe more focus put upon representations. So this rule is going to have ramifications in the M&A realm as well. All right, so that concludes the content, and like I mentioned earlier, we're going to get all the slides and the audio to you, so if we moved through the slides too quickly or you missed anything, you'll be able to listen to the presentation again, and Peter and I will gladly follow up with any questions you have. For now, let's try to run through the questions that have been submitted so far, and feel free to keep submitting them.
Okay, we did see one question asking about whether this is only going to apply to federal opportunities, meaning can you be held liable, for the total amount expended on a contract that falls outside of a federal grant, a federal set-aside contract, and the answer is no. This is a federal regulation, and so it's not going to be applicable to any of your commercial activities.
But to the extent what that questioner was getting at is whether or not it applies to subcontracts, the answer is yes, and we covered that their subcontractors will be liable for misrepresentations, and so a prime contractor needs to make sure that they're taking adequate steps. If you have a small business that is helping you to meet your subcontracting plan, you need to have a good faith basis to rely on that firm's representation, and that representation needs to be in writing. So our recommendation, just to recap, is get something in writing from them. Don't just have them say, well, we're in SAM. Have them give you something in writing with their current information, and then go ahead and check SAM yourself and do a little due diligence on your own to confirm what they've told you in writing, and then put that in your file, and that should be enough to establish that you had good faith to rely on their representation. There was also a question, what if I'm a large business supplying to a small business prime contractor? Do I have any potential exposure if that small business prime contractor made a misrepresentation? And you don't have any direct exposure under this new rule. In other words, the misrepresentation by the prime, the liability that the prime might face, isn't going to flow down to the subcontractor. But it might have other ramifications on you in terms of potential termination of the contract or loss of the opportunity. And so that's why we recommended in your teaming and subcontract agreements that you build in indemnification provisions and other protections in case all of the effort and time that you spend, money that you put into an opportunity with another firm, essentially gets blown up by the fact that that firm made a misrepresentation.
So there was a question about do you have to state before a contract award, I guess, how that contract award will affect your size or status? The answer there is no, and that's because when you certify as to your size or status, and this kind of goes back to the deems certifications and really that first bullet point, which discusses submitting a bid, proposal, application, or offer for a contract. And that is when that deems certification kicks in. So anything that happens after that certification really isn't going to affect the representation that you've already made.
There were a few questions about how do joint ventures play into size, the triggering event, and what we meant by that is when you form a joint venture with another company, under the SBA's rules, you're automatically affiliated with that other company. So there is going to be, just by the act of forming the joint venture, some ramification potentially on your size or status. And depending on the type of joint venture, if it's a small business joint venture or an 8A joint venture or a hub zone or SDVOSB, there are different rules that apply. Some of them are the same throughout the different programs in terms of determining size, but you're going to need to look at the specific rules for the type of joint venture and assess whether the two companies are going to be able to qualify as small for that project. So that's what we meant by the joint venture as a triggering event. Somebody asked, what happens if we're small based on some NAICS codes but large based on others? As long as your representations are accurate in SAM every year, at least when you're required to update it, and then on a going forward basis, you're accurately going after contracts as a small business under those codes where you're small, and you're not going after small business contracts for the codes where you're large, then this new rule is not going to you're not going to face liability under the new rule.
So someone asked, if a contract doesn't have a small business provision, does a prime need to be concerned? And I guess we're assuming here that this competition hasn't been set aside, or this contract opportunity has been set aside, and it's a full and open competition. Well, in that scenario, in submitting your bid, you're not going to be certifying as to your size or status because there is no set-aside opportunity involved. So the short answer is no.
Somebody asked whether if you are announced as the winner but then lose the contract as a result of a protest, would there then be no penalty under the new rule? There wouldn't be a presumed loss to the government, so that civil penalty based on the presumption of loss because you didn't actually receive the contract and there were no funds expended on the contract for you. But that doesn't absolve you of the other penalties, the suspension and debarment or criminal penalties. And the rule's pretty clear that you could still face liability for misrepresentation of your size or status under those other penalties in the rule. So it would just get you around the presumption of loss.
Okay, there's a question, and this is going back to when John was talking about policies and procedures. Does this, idea of, making sure that your representations are accurate, does that have to be, part of your mission statement, or is it really just a suggestion? And it is just a suggestion. But it all gets back to the fact that, at the end of the day, it's not the SBA who's going to be deciding these cases. It's going to be before a judge and a jury, and that being the case, it's difficult to protect the outcome. And so what you need to do is you need, like we said, start building your compliance file so that at the end of the day, you can show that you at least took good faith efforts to mitigate the risk of any sort of misrepresentation.
Yeah, I think Peter's making a good point, though. There really isn't none of the suggestions that we made in the second half of the webinar are explicitly required under the rule. So the rule isn't really telling you you've got to do anything differently, but, overtly. But the subtext of these provisions, we think clearly, is that you need to do some things differently, and that includes having a policy and procedures related to size and status representations. If you go forward making reps and certs without policy and procedures, you're taking a big risk. We have somebody here that asked what parties are most likely to raise a claim of loss. Would it be a contracting officer or competitors? Ultimately, the claim of loss is going to be raised by the government. The prosecutor is going to open an inquiry against a firm, but that could be triggered by a variety of circumstances, including the two that the questioner raised. A contracting officer could see something funny. It could be the result of a protest by a competitor. It could be that a competitor calls in a tip to a hotline, or it certainly could be because the competitor feels like they have some dirt on you, or just wants to stir up the pot, and sends in some information suggesting that you're not making accurate representations. So that's certainly a possibility.
And this kind of ties into what John is talking about, and what the question was asking. And that's, if the DOJ comes after you, the Department of Justice, and they bring a false claim action for your misrepresentation as to size or status, under the False Claims Act, you can be held liable for treble that is 3 times the damages. So that total amount expended on the contract that is a presumed loss to the government could, in theory, triple in size.
Mm-hmm. Okay, let's see if we can find one or two more, and then we're going to have to wrap up. So somebody asked, could any adverse size determination result in debarment and penalties? And the answer is yes. I mean, the question is will or could it? And the answer is yes. There is the potential that any particular adverse size determination could ultimately result in penalties under the presumed loss rule. It would depend on the circumstances of that size determination. How blatant was it? What are the circumstances? How ambiguous was the rule, or how clear was the representation? The types of things we talked about earlier. But in theory, yes, adverse size terminations will be something that triggers the liability. Okay, I think we've got to wrap up now. Thanks again, everybody, for joining us. There are a number of questions that we did not get a chance to answer. We will go through each of them and follow up with you individually, and we'll also make sure everybody gets a copy of the slides. So thanks again for joining us, and enjoy the rest of your day.